Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this live legal educational content, and today is the day I earned that subscription. For today's story, we are dealing with the bee fish. Yes, my friends, the bee fish are the best fish, as we all well know, and the bee fish have made an appearance at the U.S. Supreme Court in the form of the Babylon fish, a satirical newspaper in the style of The Onion. We read The Onion's amicus brief, friend of the court brief, on why this guy who made a social media site to make fun of the Parma, Ohio police, maybe not so much with it being illegal, maybe it should be freedom of speech and protected. Exciting. And to not be outdone, I suppose, in some ways, the Babylon fish has also filed a friend of the court brief espousing their thoughts. So we're going to see which is best, onion or fish. All right, let's go ahead and do that. We're in the United States Supreme Court in the petition for a writ of certiorari. We are asking for the Supreme Court's review. And in support of asking for the Supreme Court's review comes now the fish, the Babylon fish, as a friend of the court in support of this petition. Great. Let's carry on. So we've got some introductions. And then we got some authorities, which are hilarious because some of them refer to Babylon Bee titles in the past. So I will read some of these authorities because they are amusing. Aaron Judge sets a record for most home runs by a person with a normal sized head. Babylon Bee. Chuck Norris comes out of the closet as even more of a man. The Babylon Bee. That's nice. College athlete surprised to learn his school has classes. Babylon Bee, that's a good one. Cop on laptop protecting community from drivers on cell phones. Yeah. Donut sales surge as police departments refunded. FBI gets great night's sleep after raiding My Pillow Guy. That's good. FBI storms convent to arrest group of dangerous pro-life extremists. Yeah. I thought I was going to die, says Capitol police officer who held door open for protesters on January 6th. That some of the police officers may have done that. That's possible, yes. Let's see what else we got here. Police keep Antifa away from statues by taping job applications onto them. Very nice. Subway begins promotional offer where they will use real meat for limited time. Lol. Thank you for the super chats from Vanessa and Quinn. I appreciate. I also like your dancing lemon very much. It amuses me and makes me happy. Thank you for your dancing lemon super chat. The FBI raids. The FBI raid on Melania's closet was justified, says Merrick Garland wearing gorgeous new evening gown and sun hat. And Uvalde police criticize Indiana Mall armed citizen for not waiting around outside for an hour. Yeah, this is good shit. All right, so let's get into the brief proper now that we've read some wonderful. I'd like to just remind you, by the way, this is their table of authorities, which means they're citing every one of those articles as basically legal justification. That's what an authority is, right? It's like what authority speaks to your legal claim. And basically the legal authority that speaks to my claim is my own newspaper, the Babylon Bee. Hilarious. All right, let's read this amici curiae. The Babylon Bee is dangerous, far-right misinformation site that typically peddles fake news, but when its writers are up for more of a challenge, occasionally uses satire to draw on and reinforce actual misinformation and conspiracy. The Bee is part of the conservative media ecosystem, famed for its conspiratorialism and questionable reporting. Excellent. The Bee has had some success with the whole satire thing. With 20 million page views per month on its website, The Bee is quite possibly the most popular source for satire in the history of the world. The Bee has inspired many imitators, including our fellow amicus curiae in this case, a cute little upstart known as the Onion. Nice. Like Mr. Novak, The Bee is a frequent target of censorship and attacks from powerful people who don't get, or at least don't appreciate, the joke. The Bee has faced the ire of diverse groups of established media types, including the New York Times, the Washington Post, and CNN, and the wrath of the massive tech companies who functionally control the lion's share of public debate in our society. As a matter of fact, The Bee is serving a brutal life sentence in Twitter jail as we speak. Lol. Its writers would very much like to avoid consecutive sentences in a government-run facility. Truth is stranger than fiction. Often that's, yeah. And fiction is illegal, at least in the Sixth Circuit. That court's decision depriving petitioner Anthony Novak of any opportunity to hold accountable those who searched his home, arrested him, and jailed him because the parody he wrote was too effective, should be reviewed by the courts on the merit. You know, I want to take this decision as a Supreme Court justice just because it gives me an opportunity to try to flux my own comedic muscles and write an opinion in a satirical form. I mean, you know, I would totally do it. I would absolutely 100% do it. I do it as a Supreme Court justice too, just because I can write an opinion that's like trying to flex my own comedic muscles. Yeah. First, parody plays an invaluable role in a free society. When parody is imperiled, citizens are deprived of one of the most effective means of criticizing the government. Second, the Sixth Circuit ruling will allow the state to punish vast swaths of speech, erstwhile protected by the First Amendment. The Bee, which should be renamed The Fish, as we all know, and its writers could be held criminally liable for many, if not most, of the articles The Bee publishes. Good grief. The Bee could even be on the hook for publishing this brief's doppelganger. Oh. Dude. And then they say, see brief of the Babylon Bee as amicus curiae for respondents, the Babylon Bee, October 28th, 2022 at a website. See also inevitable confusion, internet commentary that will follow. Oh, joy. So they filed a formal legal brief and then basically on the exact same day published a joke brief on their own website. So we've got two briefs, I suppose, from the Babylon Bee. We will read brief number 2 at the end of this. Wow, that'll be exciting. Third, the prospect that an individual or entity charged with a speech crime might ultimately be vindicated at a criminal trial does little, if anything, to temper the speech-chilling effects of the decision below. The Sixth Circuit's qualified immunity on steroids approach means that state actors can search, arrest, jail, and prosecute offenders like Mr. Novak without fear of ever being held to account themselves. Knowledge that they may be searched, arrested, jailed, and prosecuted without recourse is enough to dissuade most would-be speakers, regardless of the potential for ultimate acquittal. Yeah, I mean, no shit, right? No shit. The fact that, you know, the state would prosecute me criminally would probably be enough to get my attention. Even if I really, really thought at the end I'd win, it's still a lot of harassment, you know? So, yeah, I mean, that's what the chilling effect is, right? Even if you think you're going to win at the end, the time, money, expense, legal expenses, frustration, anxiety is a lot. Lost and Found says, I was wrong Friday on Law and Lumber. You once shared a tiger statue that your mom painted, not an elephant statue. Sorry about that. Thanks for sharing with us. That makes a lot more sense now. Yes, thank you. And I have the tiger statue because it's one of my prized possessions. Thank you very much. I was confused. What elephant statue? But yes, thank you. I'm a Clemson tiger. It's a tiger. All right. Parody is essential to free society. The Onion may be staffed by socialist wackos, but in their brief defending parody to this court, they hit it out of the park. Nice. You got a little ribbing against the Onion in here too. That's nice. Parody has unique capacity to speak truth to power and to cut its subjects down in size. Its continued protection under the First Amendment is crucial to preserving the right of citizens to effectively criticize the government. Furthermore, parody shouldn't be stripped out of constitutional protection just because it's not clearly labeled as parody. Yeah, this was the Sixth Circuit solution to this problem, right? So I believe it was a Facebook page. In case of you who are not familiar with the background of this, Novak made a social media page. I'm pretty sure it was Facebook. That was a parody of the Parma, Ohio police. And, you know, the police basically investigated him for impersonating an officer or, you know, disruption to services or whatever. I forget the exact investigation, right? And so he was eventually acquitted. And now he'd like to sue for violation of his rights. Well, the Sixth Circuit solution to this problem was, well, you know, his page, his Facebook page, didn't clearly say on it parody. So if he had just clearly labeled it parody, then, you know, that would have been good. But it didn't. It to a superficial eye looked real. And because you didn't, to a superficial eye, say, this is parody, I am joking, you know, someone could be deceived. Yes, an idiot. But that's not normally how we do law. Normally, we do not go to lowest common denominator. This is where the ever popular reasonable man test comes in. Right? It's not the question of whether anyone could be fooled. The question is whether the reasonable man on the bus, the ordinary, common man of normal, ordinary education, prudence, and so forth and so on, right? This guy, whether or not this guy would be fooled. And, you know, when they say, you know, you can, for example, on the parody page, you can get rid of your offender registry status by coming down to this event. And if you complete some puzzles, your registry status as an offender will be removed. You know, if you think that's real, you know, I don't, you're beyond all help. But despite this, despite the fact that the ordinary common person should be able to suss out this is not real, the Sixth Circuit said, hey, what they need to do is just explicitly say this is not real. If they only said explicitly this is not real, and the Onion and the parody are, and the Onion and the fish over here are both like, dude, that kind of kills the joke a little bit. Yeah. And requiring that parody be written so as to ensure the most gullible in our society, the Facebook using grandmother, the tween on TikTok addict, the CNN reporter, cute, don't take it seriously, ruin the parody for everyone else. Yes, this is why we invented the reasonable man test, among many other reasons, right? We don't want to skew society to the least common denominator because unfortunately they keep inventing new kinds of idiots. It's not just that it's not just that there's an ever increasing supply of idiots. It's that the nature of the idiocy continues to mutate and new forms of idiocy emerge constantly. So the way we solved this problem in law long ago was the reasonable man test, right? What would the reasonable person think? Not what would the idiot believe. Because there are people idiot, and we are not going to create a society that's safe for all the idiots because, well, it would be impossible. And even if it were possible, it'd be pretty dull. The Sixth Circuit decision undermines these fundamental principles, and this court should grant Novak's request for the writ of certiorari in order to right the free speech ship. The Sixth Circuit ruling allows the government to punish vast swaths of constitutionally protected speech. True. Police, the Sixth Circuit have previously said, cannot punish the speaker as an easy alternative to dealing with the lawless crowd that's offended. Yeah. Right. That's that concept of the heckler's veto in so many words. We can't allow the offended, we can't allow the particularly susceptible to control what is allowable discourse for everyone else. I'm sorry and all, but we can't lowest common denominator this thing, because if we lowest common denominator this thing, what of the First Amendment would exist? So, yeah, we can't punish the speaker because some people in the crowd will enact lawlessly. This is why, by the way, the standard for incitement under Brandenburg is the way it is, right? Right? That people may engage in lawless behavior in response to a speaker's speech. This does not necessarily indicate the speaker is criminally liable, because it is legal to generally say people should break the law as a general proposition. Consult your attorney for more specifics. But, you know, that's why we have Brandenburg, unless it's imminent, unless it's going to happen right now. Among other criteria, we don't punish that. And we don't lowest common denominator this thing. We reasonable man this thing. Yeah. But the same court ruling in this case means police can punish a peaceful speaker if they are the ones offended. Right. So in this case, the police are the eggshell skull. And why eggshell skull might be a doctrine that we in some sense apply to battery and intentional tort, it is not something we apply to freedom of speech, because if for no other reason, freedom of speech has special constitutional protection now, doesn't it? The Ohio Revised Code makes it a felony to knowingly use any computer or other electronic device or the internet so as to disrupt, interrupt, or impair the functions of any police, fire, educational, commercial, or governmental operation. This, in general, is a fairly sensible law. You shouldn't be allowed to use a computer or the internet to impair, interrupt, or disrupt lawful operations of others, right? Your freedom to swing your fist stops at my nose, kind of thing. Your freedom of speech stops when it interferes with my lawful activity, and vice versa, right? This is a mutuality thing, right? So I can't come and disrupt your speech. You can't come and disrupt my speech. I can't use a computer to impair the functions of the business by, for example, hacking or whatever, right? That's probably a pretty good law in general. So, okay. In Mr. Novak's case, so so this is the difference, of course, between a facial challenge and an as-applied challenge, as always, right? If we want to attack a law, we can do it in one of two ways. We can do it facially, or we can do it as applied, right? Facially is to say the statute as written is just bad. It's broken. It's just broken, basically universally. Thank you, Jojo, for the 20 gift memberships. That's very, very kind of you. The other way we can do this is as applied, right? The statute isn't broken generally. It's just broken as to me. You are misapplying it as to me. So the statute may be facially fine, but of course, that doesn't stop our analysis. We can move to the as applied. So let's move to the as applied. In Mr. Novak's case, the Parma Police Department, backed by the city's law director, a magistrate, and municipal court judge, concluded that by creating a Facebook page parodying the Parma Police Department, Mr. Novak had violated or probably violated the statute. Yeah, that's not exactly what we had in mind, I don't think, when we wrote the statute. And even if it was what we had in mind, the First Amendment, right? The statute must yield to the First Amendment. Therefore, the police reasoned, at a minimum, he deserved to be searched, arrested, jail time, and criminally prosecuted. The Sixth Circuit did not disagree, concluding that the police came close enough to getting it right to entitle them to qualified immunity. That is, respondents reasonably found probable cause in an unsettled case. Judges can debate. Now, we know qualified immunity because we've covered it on this channel, and we know how expansive it can be. Sometimes ridiculously so, in my opinion. Whatever merits qualified immunity has as a doctrine, in some sort of principle, which maybe it does, the way it's been applied is a little absurd. Because in order to find a clear violation of your constitutional rights, you have to find a case that's pretty directly on point. More on point than you would in most legal contexts. And so things that seem to be violations of the Constitution never get punished because they've never been established, and they don't get established because they've never been established before, and the whole thing eats itself. So the qualified immunity jurisprudence as it's been developed leaves a lot to be desired. The Sixth Circuit reasoned that officers were permitted to rely on inferences to establish the knowledge element. I mean, as a general proposition, true. No one contested that Novak used a computer and the internet to create his page. True. And that officers could reasonably believe that calls to the police department alerting it to the parody page existed and constituted disruption. Viola, probable cause. Yeah, but once again, the First Amendment, right? This is the thing, like, as the nature of a constitutional amendment, it kind of sits on top of everything. So yeah, even if all those things, though, as applied, it's a problem. Or at least close enough to probable cause to justify a few nights in jail. Left in the hands of the Sixth Circuit and the Parma Police Department and other like-minded law enforcement, the speech-stifling Ohio statute used to go after Mr. Novak empowers state officials to search, arrest, jail, and prosecute parodists without fear of ever being held accountable. Yeah, this is a broader problem than the First Amendment domain. And if the Supreme Court wants to take this up as an opportunity to reevaluate qualified immunity, I'm here for it. I'm here for it. Maybe this will be the case. Maybe this will be the case. The Supreme Court will take up and not only say, hey, that was established, but also reform the entire qualified immunity doctrine. Personally, I'd be happy if they just said that the Court of Appeals was required to establish whether or not something was a violation for the future. See, this is the problem. This is the problem, right? The problem is the courts of appeal. The courts of appeal say, okay, in order to find a violation under 42 USC 1983, we need two things, right? We need two things. There was a violation, and that violation was clearly established. Now, getting to one is usually not that hard in a 42 USC 1983 case, because most attorneys, of course, are not going to bring a case that doesn't satisfy step one. So, getting to step one, it violated our rights, is not too hard, although it's still difficult and certainly not present in every situation. But, in the grand scheme of things, there's a lot of step one. The biggest problem is that we never get to step two, clearly established, because here's what happens, right? We have a violation of rights, but it's never happened exactly this way before. And as I've said, unfortunately, in this particular area of law, when we say clearly established, what we mean is we need a case that's pretty damn on point. You always need a case that's on point. You need like authority or a reason to establish new authority from nothing, which usually requires still authority, right? Even if you're in some sort of new domain, you're usually almost always reasoning by analogy. So even if you have a completely novel situation, which really doesn't happen that often to be completely novel, but it happens occasionally. Even if you have a completely novel situation for which there's no case law, what you usually do in that situation is you analogize by the nearest closest case law, which might be 10 years old or 50 years old or 400 years old, right? So normally you have some sort of authority somewhere that says, okay, here's what we've done in the past. Let's extend it by analogy into this new domain. So you kind of always need something. The degree of the something you need is somewhat proportional to your ask, if you want a general proposition, right? The more incredible, the more extreme your ask, the more authority you're going to need, right? It's like you're going to have to prove this to greater and greater levels because you're asking for more and more, which kind of makes sense, right? It's like justify your ask. Great. But the problem is in the 1983 arena, in this qualified immunity arena, the courts have by their case law said, okay, you basically need something that's really, really on point. So you can't do this normal legal thing. You can't do this normal legal thing of, okay, I've got a case from, it's not quite right, but I've got a case from 5 years ago, let alone 10 or 20 or 50, right? You need something that's really, really close. Okay, so that's really hard to find something really close. So then the courts of appeal look at it and say, hey, this thing that violated your rights, there's nothing on the books. So you lose. The problem is the courts of appeal never go to the next step of saying, or very, very rarely, they sometimes do, but it's very rare. They very rarely go to the next step of saying, okay, forward looking, this is a violation of the Constitution or not. They never make the forward looking decision. We don't want to have the law be retroactive. Okay, fine. But in the future, what are we going to do? So they never say, okay, we're now going to clearly establish because, hey, no one's ever said it before. So this officer couldn't have known. But in the future, just know X, Y, Z. But they almost never say that, which means the next time it happens, the next time the exact same thing happens, the exact same problem occurs, right? 2 years later, another officer does the exact same thing. Well, it's never been clearly established. We're not going to clearly establish it now. 2 years later, well, it's never been clearly established, and we're not going to clearly establish it now. So it can only become clearly established if it's been clearly established. And if it's not been clearly established, it won't be clearly established. So this is the biggest problem with qualified immunity. First, I think the standard is a bit too high in the first instance. I think the degree of closeness required is too tight, right? Because again, there's that sort of how close does the prior case need to be to what I'm asking for? So as I suggested, the degree of the ask somewhat constrains the nature of how close I need. If I'm asking for a lot, I need something very close. If I'm asking for not very much, my propositions are wider and I can use more authority because I'm not asking for very much. So I'm allowed more latitude. As I am asking for more, I'm going to need something closer, closer, closer. So problem number one, in my opinion, is I think the standards in the 1983 arena are just requiring too much. They're the ask. What the courts are requiring is disproportionate to the ask, in my opinion. That's problem number one. But even if that wasn't a problem, big problem is number two, is that the courts are not required to say, forward-looking, whether or not this is a constitutional violation. Maybe it's not. I don't know. Be nice to know either way. That'd be good. And so, like, if you want to fix this problem, the biggest thing you can do is just say, okay, courts of appeal, every time you're faced with this, you have to say whether or not going forward this is or is not a constitutional violation. Just clearly establish it. And then we know. And then we can move forward. And then the case law will develop and we'll know whether things are a violation, and we won't keep having this problem. So, you know, if wishes were horses, this would be what I would like to do. Or we can go back or option two, we can abolish the entire qualified immunity analysis and go back to the old case, which was Skidmore, where we just go to the reasonable man test. The reasonable man test was great. Remember I talked to you about the reasonable man test? It's great. We solved this problem long ago with the reasonable man test. It was fantastic. So what we can do instead is we could just abolish the entire qualified immunity doctrine and just go back to Skidmore. Skidmore is just the reasonable man test. We call them the reasonable officer because, you know, the reasonable man now is a little bit more specific because it's not just any reasonable person. Now it's the reasonable officer because we're talking about the police, but that's okay. We've done this before in other domains. It isn't like the first time ever. You find cases talking about the reasonable barber, the reasonable doctor, the reasonable plumber, the reasonable whatever. It's just the reasonable man test in a more specific domain as is appropriate. So let's just bring back the reasonable officer test. It was great. And we'll just ask the same question we basically ask all the time. The reasonably prudent, normal officer, a normal, educated person of reasonable prudence and common understanding, what would they do? You know, and if it's not the reasonable officer, then, you know, that would be fine too. So either of these solutions would work for me. Jojo gave $5 to say, I learned so much from Kurt. While I love other law channels, you explain more of what's going on. Excellent. I'm here to help. Nicholas Starro gave SEK 50 to say, if you make something foolproof, the universe takes it as a personal insult and invents a bigger fool. True. Rise Again gives $2 to say, the babying coddling of the police in US needs to end. Yeah. So here are a couple mechanisms to do it. Here's a couple ways to do it. In varying degrees of how far do you want to go? As the Supreme Court, for example. How far do you want to go, Supreme Court? Here's a couple options. Option number one, require the Court of Appeals to just clearly establish it. Option number two, do that and also make it a little bit less exacting of a standard. Option number three, how about we just abolish the entire thing and make Skidmore great again? That could work. Thank you, Patty C, for the Sunday morning love. I do love Sunday mornings. Thank you. And I love you guys here. Anyways, that was a lot of legal analysis. I went on a little rant there for a second. Sorry that during your entertainment, I tried to teach you something. Okay. All right, carrying on. The upshot for the Bee is that in Ohio, at least, its writers could be jailed for many, if not most of the articles the Bee publishes, provided that someone contacted law enforcement or another entity protected by law to tell them the article exists. Take a simple example. Last March, a headline from the Bee trumpeted, donut sales surge as police departments refunded. Funny stuff. But suppose someone, anyone, had called the Parma Police Department to let them know the Bee had published the article. In Ohio, the Bee could have been charged with a felony, its offices searched, and its writers arrested and jailed for days, all without consequence for the parties doing the charging, arresting, jailing, and searching. Yeah. And what if Officer Riley or Officer Connor's passive-aggressive brother-in-law had forwarded the article to one of them at his official police email address, and then, heaven forbid, Officer Riley or Officer Connor had then opened the email and read the headline while on the clock, thus interrupting his workday? Same result. A search, arrest, and felony charge for the Bee. As with other news organizations of similar caliber and eminence, local police are a regular focus of the Bee's hard-hitting journalism. But their federal counterparts star even more frequently in the Bee's digital pages. It was the Bee, after all, that first reported on these recent antics at the FBI. FBI storms convent to arrest group of dangerous pro-life extremists, and FBI gets great night's sleep after raiding My Pillow guy. But the Bee would be safe from the wrath of Parma's finest and their ilk in these circumstances, right? Since the FBI is a federal agency and not an agency of Ohio or one of its subdivisions? Wrong. The Ohio statute makes no distinction. Thus, had a caller contacted the FBI field offices in Cleveland or in Cincinnati to inquire about one of these stories or express outrage over the suspicious timing of the FBI's raid on Melania Trump's Mar-a-Lago closet and Attorney General Garland's acquisition of haute couture wardrobe, the Bee would have been subject to felony charge and the writer jailed under Ohio statute for disrupting, interrupting, or impairing governmental operations. Truth. And then they could hardly be more open and shut case for the enforcers of law and order in Ohio than that of the story of the Bee reporting on the testimony before the January 6th committee. I thought I was going to die, says Capitol police officer who held the door open for the protesters. The article concluded with this self-incriminating line: the FBI has issued a warrant for the man who called the officer a cupcake and is asking anyone for information to call Nancy Pelosi's office immediately. That story is, by Sixth Circuit lights, dripping with probable cause. After all, the article expressly asked readers to play their part in disrupting, interrupting, or impairing governmental operations by calling the Speaker of the House and thereby momentarily inconvenience one of her staff members. All this is not only the tip of the iceberg, as the statute criminalizes not only disruption, interruption, or impairment of police or governmental operations, but also disruption, interruption, or impairment of fire, education, or commercial operations as well. Thus, the Bee and its writers could have been variously subject to search, arrest, jail, and prosecution for the publication of hundreds of articles unrelated to policing or governmental operations. Consider college athlete surprised to learn his school has classes. Had a reader called the Office of Academic Affairs at The Ohio State University about his article, that would have been enough for law enforcement, without fear of being held to account for themselves, to arrest the Bee staff for disruption of educational operations. Likewise, for the article, Aaron Judge sets record for most home runs by person with a normal-sized head, and Subway begins promotional offer where they will use real meat for a limited time. Had someone contacted either the Guardians or the Reds about the former, or an Akron Subway franchise about the latter, then it's goodbye freedom for the team at the Bee. Per the decision below, Parma Boys in Blue could reasonably find probable cause at that point and therefore search, arrest, charge, and jail with impunity. I mean, you know, they are pointing out the absurdity of taking the Sixth Circuit's position to potentially its logical conclusion, which, you know, is it's a common tool in legal, right? Where does this stop? Is usually a pretty good answer or a pretty good question in any legal case. You hear it all the time. It's one of the reasons the Supreme Court does things the way it does in particular. It's the way they craft questions. It's behind a lot of their questions. Where does this stop? What are the limitations of your principle? Because, basically almost any principle without limits becomes a problem. This was, who was it who said that? It was Aquinas or someone like that, who basically argued that every virtue taken to its extremes becomes a vice. It was someone like Aquinas who said that. And it's basically right. Like everything you think is good, taken to extremes, becomes bad. Because it winds up eating all other good things in the name of its virtue. So, caution can become, for example, cowardice. Or its other extreme would be recklessness or something like that, right? So cautiousness exists in the middle of cowardice and recklessness, maybe. So the principle taken to either extreme becomes a vice. And pretty much true for most virtues. So, yeah. So, where does it stop? Is usually a pretty good legal question to ask. It's like, okay, you might be right in this instance, but where does it stop? And when you're the Supreme Court in particular, you have to ask that question because you're speaking to broad principles. That's what you do. You can decide a case on its own merits and you can limit it to that case. You can do that, but that's not your typical mode of operation. So you got to think a little bit more broadly than that. Aristotle, virtue ethics. Aristotle sounds probably about right. It's probably Aristotle. Thank you for the chat. Yeah, Aristotle, that sounds right. Thank you. In short, vast amounts of protected speech are swept up in this criminal prohibition of alarming breadth. When local police and federal appellate courts officials, both high and petty, join forces to execute and then condone the search, arrest, jailing, and prosecution of parodists for protected speech, the very core of the First Amendment is rendered a dead letter. I mean, yeah, a little bit. Thank you, Rabbit, for saying you appreciate my direct approach. Not everyone likes it. Just try to tell you things. Just try to tell you things and try to be, an honest broker and, just be like, okay, here's what is going on. So, I mean, some people like that, some people don't, I guess. I mean, I'm not going to be to everyone's taste. That would be an absurd thing. But I can be to your taste, and I can be to the people who will join this channel's taste. I will be who I will be, and hopefully tomorrow I'll even be a better version of myself. A more complete, well-rounded, and even more entertaining and fun Uncivil Law. Honesty can become crude. Yeah, there's fairness there. It's true. Although I do like Kant's idea of the categorical imperative. I always liked Immanuel Kant's philosophy. I don't know that he's right in the extremes of it, but I do like his categorical imperative, and I like his idea that truth is a categorical imperative. So Kant would say that truth is a virtue without limits. So, testing the principle of Aristotle, I guess. But okay. Where qualified immunity deprives a speaker of civil remedy, acquittal for a criminal speech charge is called comfort. Mr. Novak ultimately was acquitted of the felony charge leveled against him, and the B hopes that when its turn comes to face the Committee of Public Safety in Ohio, the result might be the same. But this court should not confuse acquittal in circumstances like these with vindication of robust free speech rights enshrined by the Constitution. This goes to the most troubling aspect of the Sixth Amendment decision. Certain passages that are of the opinion give the impression that the court's sympathies lie with free speech. The court, for example, purports to regret that neither of the police officers nor any of the other state officers involved ever put the brakes on the search or arrest or jail time of the criminal charge wrought upon Mr. Novak. But the aggressive form of qualified immunity the Sixth Circuit adopted, in fact, gives state officials a blank check to continue suppressing speech with these same means. Again, this is kind of a bit of a universal problem. The Sixth Circuit's decision here is, unfortunately, in keeping with the qualified immunity zeitgeist. This, in my opinion, is a reason why the Supreme Court should reconsider the qualified immunity zeitgeist, because they can and probably should, and maybe this is a good opportunity to do that, just saying. You know, maybe I'll write an amicus brief if this gets to the merit stage. I've never written one before the Supreme Court before. Could be fun. Maybe I'll write an amicus brief if this gets there, and I'll say this is a good opportunity to reconsider the entire qualified immunity doctrine while you're at it. So if this gets to the merit stage, I might write something. Then I'll have to crowdfund the printing costs because they're pretty fucking expensive. But I digress. The Sixth Circuit purported to leave the parties in a state of relative parity. At the end of the day, the court opined neither side got all they wanted. Little did Anthony Novak know that he'd wind up a defendant in court, so too for the officers who arrested him. But in fact, the contrast between the parties' position could hardly be starker. The Sixth Circuit's decision allowed respondents to deal a felt blow to the First Amendment right to criticize the government while at the same time leaving Mr. Novak without any means of redressing this grievous constitutional violation. True, both Mr. Novak and respondents were, as the court's opinions say, defendants at one time or another. But Mr. Novak was a criminal defendant subject to the ordeals of criminal trial, including the fear of imprisonment, public humiliation, and financial strain. And he was not just any criminal defendant. He was a criminal defendant and subject to search and arrest in jail for not having done anything wrong. Yet he escaped criminal liability only because the jury adjudicated him not guilty. Respondents, by contrast, were mere civil defendants. And even though they had violated the First Amendment rights, they were afforded the luxury of avoiding trial altogether. Moreover, though they lost Mr. Novak's criminal case, respondents still managed to get what they wanted: thorough and efficient suppression of Novak's speech criticizing the police department. Yeah, they sure did. In hell, right? Okay, great. Thank you for the $5, by the way, who's someone who sent into PayPal. I appreciate that. Let's see, where was I? They intimidated Mr. Novak into removing his Facebook page and then by arresting him, searching his apartment, jailing him for 4 days, and foisting a criminal trial upon him, making it all but certain that he and anyone else paying attention would never commit a similar speech crime again. Yeah, a little bit. That is the nature of the chilling of speech. The only means Mr. Novak had to counteract this thorough suppression was to lodge an ex post civil suit against respondents in the hopes of holding them accountable. Yeah, a little bit. Sorry, had a little technical trouble there that I had to fix real fast. Hope it didn't disrupt anyone. $5 from Stacy Warple. Listening to you reminds me of chatting with my dad, who was chief judge on the Fifth Circuit located in Louisville, or Lafayette. I apologize, Lafayette, Louisiana. I miss him. Now I have a lawyer YouTube. Excellent. Thank you. I appreciate that. If you know any of your judge's colleagues and they're looking for a clerk and or the ability to appoint me to the bench, let me know. I'm available for either. $5 from Ricardo Ospina. The right and left don't often agree. Hopefully qualified immunity can get challenged to something that's more reasonable. Yeah. If you are a federal judge or have connections to those that are, let them know that I am available. I can be appointed as a judge. I can be a clerk. I can express my musings in official legal form that will bind us all in some sort of dystopian nightmare. If you're in for that, let us know. The only means Novak had to counteract this thorough suppression was to lodge an ex post civil suit against respondents in the hope of holding them accountable. There was and no other effective remedy available to him or countless others whose federal constitutional rights are similarly abridged. But the Sixth Circuit closed that door to Mr. Novak, leaving him bereft of recourse. To aggrieved party or right without remedy is doubtlessly not much better than no right at all. The B has no reason to believe the result would have been any different should Ohio authorities choose to bring a parody in violation charges against one of its or its writers. I feel that. Sure, if the B were to roll the dice with the jury, sanity might prevail, but that's of course by no means assured. That's, absolutely correct. And even if criminal trial victory were in the bag, without a means of dissuading state actors from continuing to arrest and jail speakers they don't like, any such victory really would just be a less extreme loss. Yeah. The writers of the B are a hardy bunch, accustomed to regularly and brilliantly absorbing blows from powerful, prestigious media outlets, and also from CNN, that desperately want to muzzle the B. Child's play. But whining establishment types who are unable to take a joke and who possess coercive power of the state are an entirely different matter. And for that mix of aggressive, unbridled strain of qualified immunity propagated by the Sixth Circuit, it's enough to make Chuck Norris sweat. Thus, the conclusion. Well, the B on the whole took a more serious tone with their brief than did the Onion, but nevertheless, quite fantastic. Quite fantastic. Some jokes peppered in, but a more serious tone on the whole. The Onion's brief was a meta commentary on itself, and also, as a result, very confusing. Is it real? Is it fake? Is it a parody? Is it a shoot or a work? To borrow wrestling terminology, Is it a worked shoot? Is it a shot work? Is the work shot work? What work? It was very meta and got very confusing as to what's reality and not, which was great. It was fantastic. It was everything you would ever hope for. The bee fish brief was more serious in tone, but also excellently well written. So yeah. Thanks for the reminder, 17. I had forgotten to read the second brief. Thank you for the reminder. Yes. So 17F gets bonus points for reminding me. It's very, very short, though. I'll just read it to you. It says, we have filed an amicus brief arguing that parody is dangerous. Greetings, the Babylon Bee readers. You may or may not be aware of the case of Novak versus City of Parma, Ohio. A quick rundown for the layperson. Mr. Anthony Novak was temporarily jailed for creating a parody Facebook page of his local police department. He has thus far been unsuccessful in suing for damages. The courts have ruled the police have qualified immunity, a sadly unfortunate common thing, and are so asking the Supreme Court to review the case. While the knockoff The Babylon Bee site The Onion filed a petition in support of Mr. Novak, we reject Mr. Novak's claim that parody is protected free speech, as parody is dangerous to those with cultural and political power, and it can hurt people's feelings. On October the 28th of 2022, we at the Babylon Bee filed an amicus brief with the Supreme Court of the United States in support of the government, as nobody should be made fun of in this country. Here is an overview of the legal argument. Here's an overview of our unsaleable legal argument. Argument, part 1. When the First Amendment was written, jokes hadn't been invented yet. Part 2. Parody is bad because it can make people doubt trusted institutions such as the government. Part 3. When satire criticizes those in power, it makes them sad. Part 4. We can never truly enjoy our freedoms as Americans if we know that someone, somewhere, might be making fun of us. I almost wish they had filed that brief, to be honest. I almost wish they had filed that brief in support of the government. That would have been even funnier. They filed a brief that's supposedly in support of the government and just written that. That might have been even better. But sadly, they didn't do that, so. Oh well. Oh, did they? Oh my God. Oh, dude. Dude, they did. Well, they didn't file it, but they wrote it like they filed it. Oh, shit. Oh, man, there is an entire brief. Oh, damn, I don't have very long. I've only got 30 minutes. We're going to have to speed through this one, guys. Holy shit. They actually wrote a parody brief. They didn't file it, though, I think. But they filed a parody brief. Holy God. Or they wrote one, at least. I don't think it's real. Hold on. Talk amongst yourselves. Okay. Here is a brief. Wow. Here is a brief that they didn't file. I've only got 30 minutes, and so we've got to speed through this a little bit. But here is a parody brief. Shit. Wow. Okay. The Supreme Court of the United States, they should definitely file this for the violence. They should absolutely file this. On petition for writ of certiorari, the Supreme Court brief of Babylon Bee is amicus support and support of respondents. Wow. Wow. Okay. All right. This is a thing that's happening. They should absolutely 100% file this. Yeah. In 30 minutes, I'm going to be over on Legal Bites channel playing a game. So yeah, I gotta make this. So because I have a pre-existing commitment. to appear on Legal Bytes channel in 30 minutes. So I guess I can also redirect everyone over there too. That's actually not a bad idea. So let me do that real fast, set up a redirect. And then you guys can all watch me play a game. That'll be fun. Great. Excellent. All right. All right. The Babylon Bee is the world's most popular news site, bringing deadly serious 100% accurate stories to the public's attention since 2016. The Bee has inspired many imitators, such as the Borowitz Report, Mad Magazine, and rival news organizations that unfortunately filed in support of the petitioner in this case, The Onion, often described as a less popular secular knockoff of the Babylon Bee. Since its inception 6 years ago, the Babylon Bee has been cited in congressional hearings, tweeted out by the once and future President of the United States, Donald Trump, and shared by millions of confused grandmas on Facebook. The Bee receives tens of millions of visitors every month, boasts millions of followers on popular media sites like Facebook and Twitter, and also Truth Social, and has published over 10,000 articles containing a total of no fewer than 2 jokes. Yet the Babylon Bee has faced tremendous opposition in its brief life. The site's account was unceremoniously banned from Twitter merely for honoring a public official with a prestigious award when they gave Rachel Levine Man of the Year. Lol. CNN's Brian Seltzer called it fake news. Snopes has fact-checked dozens of its articles and incorrect and libelously labeled them as false. And thousands of liberals have left mean comments on his Facebook page. Thus, the Babylon Bee knows what it's like to have people be mean to you. It files this brief in support of respondents in this case, as is the editorial staff's direct interest to make sure that people cannot make satirical or sarcastic critique of, polished parody pages of, or post mean Facebook comments concerning the Babylon Bee because it really does hurt their feelings. Oh my God, why didn't they file this? Holy shit, why didn't they file this brief? This is great. This is everything I want to be, man. This is better. When the staff of the Babylon Bee were alerted to the pendency of this case, they immediately realized the importance of filing a brief in support of the Parma Police Department and City of Parma. It's essential to protect those with coercive power who wield it for self-protecting ends. Plus, the Babylon Bee just really like police officers, what with their badges and guns and stuff. They're so cool. Moreover, deep philosophical and constitutional issues are also at stake. First, the abuse of the First Amendment should not be tolerated. The petitioner seeks to turn that provision into a living amendment, stretched beyond its original meaning to include humor and laughter. That is dangerous, as a clear reading from the Constitution that laughter is never expressly mentioned, and it's a slippery slope we do not want to slide down. Who knows what other kinds of speech might eventually be protected by the Bill of Rights? Speech from people we disagree with? Second, our society can only function if people get their information from tightly controlled source that has never lied to us, like the government or the police. Then they can know it's 100% accurate. Petitioners' case threats the status quo. They should have absolutely filed this brief instead. This is much better. Third, the feelings of those who are being made fun of, rarely considered in free speech cases like this one. In other words, when assessing the particular speech is protected by the First Amendment, I'm half tempted to just file it myself because I can. Lol. Speech hurts someone's feeling. Fourth, it's impossible for us to function as citizens and humans if we suspect someone might be snickering at us behind our backs. That individuals might be allowed to use frivolous lawsuits to harass those who protect society from the sort of collapse is too much to hear. The petitioner in this case, Anthony Novak, appeals to the First Amendment. But this argument does not hold water, for the Founding Fathers never intended for the First Amendment to protect jokes because jokes had not been invented yet. Historians mostly agree the first joke was told by Bob Joke of Toledo, Ohio in 1927, well over a decade after the Constitution was written. It was, a copper walks into a speakeasy and the bartender says, "Get your own giggle water, kiddo." Its meaning has been lost to the ages. Clearly then, unless James Madison had a time machine, the framers of the Constitution only intended the First Amendment to cover serious talk and not jokes. I'm going to need about $10,000 so that I can file this, because I'm admitted to the U.S. Supreme Court bar and I can. I'm going to need about $10,000. Yeah. The printing costs are outrageous. All right. Anyways, clearly then, Madison was thinking the First Amendment would cover speeches that existed in his day, such as "Tally ho, old boy, fetch me that powdered wig," and "The Johnson farmstead acquired 3 new chickens last fortnight." He was not thinking of parody pages of local police departments, memos featuring pictures of minions, or jokes about the relative size and obesity problems of your mother. Wow. Ricardo Espinilla, $50 first to donate. Thank you for your donation. That's very kind. This, of course, does not even mention that the internet itself had not been invented yet. Al Gore wasn't even born until 1948. In short, the First Amendment cannot cover Novak's disparaging parody of fine, upstanding police officers in this case, because he did not write it with quill and ink by the light of a lamp fueled by whale oil. Much as how the Second Amendment was only intended to protect citizens' right to bear muzzle-loading muskets and not fully automatic, not fully semi-automatic 30 magazine clip assault pistol grip firearms, so the First Amendment cannot be applied to parody. Good damn, why did they file this? This is much better. Parody is bad because it can make people doubt trusted institutions such as the government. One aim of parody is to mock ideas that satirist disagrees with, which is great when parody is pointed at acceptable targets, such as when people often disagree with. But this dangerous weapon of free speech is pointed towards other state officials. It becomes a deadly cannon of fascism aimed right at the heart of our democratic norms. Throughout history, we find examples of the powerless speaking out against the powerful, and every time we find the people who spoke out were on the wrong side of history. The powerful were always right. If they weren't right all the time, they would never be able to achieve such power. That's just science. And then they cite, as a source for that, Mao Zedong, The Great Leap Forward. Wow. That's a citation for you. Think how much more effective the government could be if we banned comedy. Police officers could do whatever they wanted. Bureaucrats could rule with impunity. Presidents could get away with murder. Well, more than they already get away with anyway. It's really annoying and inefficient for the government when comedians are running around criticizing them. It can ruin their whole day. When satirists criticize those in power, it makes them sad. We ask the court now to recall the fable of the emperor with no clothes. That insensitive, unruly child with no filter and strong belief in the First Amendment shouted for all to hear, "Hey, look at that dummy who's not wearing any clothes." Of course, this story is supposed to teach us that we must take a brave stand for the truth, and unpopular speech is sometimes correct. But no one ever thinks how sad it made the emperor. Everyone praises the little boy for his daring and truthful statement, but nobody considers that the emperor might not have enjoyed being made fun of. Imagine being up there all naked and whatnot, and everyone starts pointing and laughing at you, shouting things like, "Check out that dude's massive gut," and "Nice farmer's tan," and "Were you in the pool or something?" Just not cool on any level. The court must consider the disastrous effect satire can have on the self-esteem of those who run our trusted institutions. Studies show that people with low self-esteem have a harder time running everything and telling people what to do. This will be an unmitigated disaster for our society. Have you ever seen how sad Joe Biden looks? That's because a lot of people on Twitter make fun of them. Thus, this shows that satire and parody are unacceptable in the current year because they make people sad. This brief is better. This brief is best brief, and I'm sad that this is apparently not real brief. I am sad. This should be real brief. We cannot we cannot truly enjoy our freedoms as Americans might know that someone somewhere is making fun of us. The petitioner in this case wants us to believe that free speech is more important than police officers' freedom from having to make someone make fun of them. They want us to believe that the right to tell jokes is more important than an entire police department not looking foolish in front of the community. That is a dangerous argument, probably shared by Hitler. Freedom requires public safety. And when public safety is threatened by the sadness of an authority figure, stopping people from joking becomes literally a matter of life and death. As we all know, any use of governmental power that saves even just one life is always worth it and will never backfire in any way. History clearly shows us. Ricardo Ospania gives another $50, says, sorry, this is another 50. I haven't laughed this hard in a while. Go file that brief. Thank you, Ricardo. If anyone making fun of police officers can threaten public safety, we must ask this court to consider the utter carnage that could be inflicted on the citizens of this country if unregulated comedians were free to make fun of anyone and anything at any time. The knowledge that someone somewhere out there is making fun of you and is an existential threat to one's mental health, and by extension, a threat to the health of the entire country. How can we feel free to pursue happiness if we become the butt of a cruel joke? Well, I mean, they have a point, I think. As someone who has occasionally been the target of mean words, and the mean words did in fact make me sad. As someone who's been the target of mean words, and those mean words have at times made him sad. The First Amendment that protects the mean words is really inconvenient. It would be nice to just completely shut down all my critics for the mean words. I think the Babylon Bee has a point. I think the First Amendment's been misinterpreted all these times. It clearly doesn't protect words that make people sad. This new and exciting revelation of constitutional interpretation has been brought to you by the Babylon Bee. In short, parody must be eliminated, and humorists should be rounded up into camps and shot. Too good for them, I say. It's worth it if it saves just one person from being laughed at. This is great. And then apparently there's a footnote. Do you believe all this stuff? You're not smart. The police's arguments are lame. To see what we really think, read the brief we actually filed at the actual Supreme Court. I am sad that they didn't actually file this brief. This disappoints me. I'm gonna write them an email and beg them to reconsider. Well, fun. This has been great. Yeah. So I appreciate the 660 of you who are currently here. Let's hang out for 10 minutes. And then we'll all go over to Legal Bytes and have fun there too. We're playing Crypto Cartel today, which is Legal Bytes' brother's game, Andy the Game Maker. We're going to play it on Steam together. We're going to have fun. It's going to be a good time. And then Andy is going to be on my channel on Friday, this upcoming Friday, where we will play it together as well with some comedians and shit. And that's going to be fun. Stuck on strings. Check footnotes on previous page, I will. Oh my goodness, my Guinness. I can't stop laughing. Your delivery is priceless. Well done. The truth is contained in footnotes. Let's read some more footnotes. Okay. All right. I'll just read all the footnotes because they look like they're all pretty hilarious. Okay. Footnote 5 says, see, for example, liberals are angry America still exists. West Dakota Times. Let's see. Footnote 6 was the Mao Zedong, the Great Leap Forward. Oof. Footnote 7, which was studies have shown that people with low self-esteem have a harder time running everything and telling everyone what to do. Footnote is see, for example, Joseph Stalin, the collective works of Joseph Stalin. And then this is a dangerous argument probably shared by Hitler. Footnote 8, see Adolf Hitler, Mein Kampf, Eich, Ofgen, Strudel, Unser Gesundheit Staffenbein. Okay, I got to put this on the screen because yeah. See Adolf Hitler, Mein Kampf, Ike Ofken Strudel, Unser Geburtstagsstaffen, Kulaflocken der Bagel, Hep Stefan Spogel Hofstengel, 9999, Croffen Bag of Week 24, star 01, $ 95, star, #, 0 at 1, exclamation. Okay, that, yeah, all right. How's my German doing? Probably not great. History, and then it says, we all know any use of government power that saves even just one life is always worth it. It'll never backfire anyway. History clearly shows this. But, and then they cite, but CF, which means see counter example. That's great. That's great. That's good. That's good one. CF means basically counter example. History clearly shows that this will never backfire, but see counter example, all of history. That's a good one. And then footnote 10, which is, in short, parody must be eliminated. Humor should be round up in camps and shot. Benito Mussolini is revealed as his political speeches, is blood which moves the wheels of history. Woof. And footnote 11, which we read, that says, do you believe all this stuff? You're not smart. They should absolutely have filed this, though. This is too good. Am I going to do a great video on Slaughterhouse? Yeah, sometimes. Atlas Knife and Tool gives $2 to say, quit itching, Kurt. It's very distracting. Well, if something itches, I'm going to scratch it. So, you know, deal. Atlas Knife and Tool. No. Rivichin says $5. Are you going to do great cases on the Slaughterhouse cases? Yes, probably. Silver Crypto becomes a new member. And Nathan Lanier says $4.99. I'd love to hear you take some time on Governor Ducey suing the federal government over stopping Arizona from putting shipping containers along the border. I might well do that. Very exciting. This is good times. Good morning, everyone. I know German, and this parody German is hilarious. I'm dying. I'm glad it's working for you. I'm glad it's working for you. I mean, I don't know German, so yeah. Best footnotes ever. The footnotes are pretty solid. I mean, I won't lie. Well, my friends, I think that will conclude our time together. What game? Yes, we're playing the game Crypto Cartel. It is a game invented by Andy the Game Maker, because he's a game maker who makes games. We're playing the game Crypto Cartel, a game I've never actually played before. So I'm excited to play it and also win. I'm going to win. I'm going to beat the person who invented the game and also his sister, Legal Bytes, and prove my dominance over everyone. It's going to be exciting. So you absolutely should tune in for that on Legal Bytes channel. You'll automatically be redirected that way as well, so that you can tune into that gloriousness. Thank you for the nice wishes of luck, yes. Ein Bier bitter. I want beer, please. Yeah. One beer, please. Ein Bier bitter. Yeah, that's a good it's a little bit good German. Quick disco? Should we have some quick disco on our way out? Let's have some disco on our way out. All right. Yeah, I actually gotta go. I gotta go and get this set up, guys. They want me there right now to set this up. So no disco time. All right, I gotta go and get this set up, guys, for the game. I'm gonna redirect you that way. I will see you over that way. Until later, my friends. Cheers. Goodbye.